So I'd like to introduce Tim Shen. He's an intellectual property attorney here in Houston, running his own practice. He has over 20 years of experience in intellectual property. Prior to opening his own practice, he worked at BMC Technologies as a consultant there. And he also, you might recognize his name because he helped defend Brian Hart against Apple and won. So, which is, I think, the more impressive part of that. So now his practice works on intellectual property, contract negotiations, and corporate counseling services. In addition to that, he also supervises the trademark clinic for the South Texas College of Law, where they have helped over 100 companies for free do basic trademark searches and licensing. So from here on out, I think I'll let Tim tell his own story. And
Thank you. Appreciate it. Good to be with you today. I did help Brian Hart with Apple, but it was really more of a settlement. I think I was just being a nuisance. I was a nuisance to Apple, and they decided that it was cheaper just to go ahead and resolve the matter with me versus going any further. So that was, but still a small victory. I'm here to talk to you about intellectual property and the value of intellectual property. Let me start out with the big question. What is intellectual property? You've heard that phrase. People talk about it, and you may not be able to really quantify what is intellectual property. Well, let me start out by saying intellectual property, think about it, is what is not intellectual property. When it comes to property law, two big areas. One is real property, this building, the land that we're on, your house. Think of that as real property. It's not intellectual property. And the other thing would be personal property. The table, the chairs, the clothes you're wearing, the computers here, that's considered personal property. Again, it's not traditional intellectual property, but the more you think about personal property, like the projector, your cell phone, the more you're thinking, wait a minute, my cell phone seems like it may have some intellectual property. Versus, if you think about this building right here, you're not really thinking about intellectual property. But when it comes to personal property, you start thinking about perhaps there's some intellectual property within your personal property, and that's absolutely true. With new technology, with your PC, there's no doubt that there is intellectual property within your personal property. So that's not unusual to start seeing intellectual property and personal property commingle and be combined. Great example would be a CD, a music CD. Clearly there's intellectual property in there. Everybody here would appreciate that music is considered intellectual property. It's copyrighted. When you're watching DVD, with all the warnings out there that you cannot copy this. It's a movie, but it's a piece of intellectual property that's on a medium, which is a DVD. But next thing. But true intellectual property, they're talking about all the intangibles, the things that you really cannot touch or feel, smell, your idea, your invention, methods, software. All those are intangibles that's considered to be the traditional intellectual property. The focus right here is talking about how do you take intellectual property, which are the intangibles, and convert that into something useful, into something tangible. When people talk about intellectual property, they're really talking about what's called intellectual property rights. The intellectual property by itself are the intangibles, but it's the ability to create, to turn your intellectual property into real property rights. That will give you value. That's the creation of value, because once you have intellectual property rights, then those rights can be bought, they can be sold, they can be licensed, they can be transferred. So the focus of this presentation is talking about how do you take your ideas, your concepts, your methods, those are the intellectual property, and convert that into real intellectual property rights, which can be licensed, sold, and which will have value. The bottom line, I think, for starters, is about creating value, at least for your shareholders. From your standpoint, you want to do something different, it's challenging, it's inventing, but ultimately, if you're talking to investors, people who are putting money into your business, you're talking about what is the value you're creating. Obviously, there are two categories. One is you have an idea, you have a strategy, and that will lead to the creation of a product or service. That's value. And it could be an app, it could be software, but you're creating something that you think will create value. But at the same time, you need to think about intellectual property rights, which is the legal aspect of it, because at the same time you're creating physical assets, you could also be creating intellectual property rights, which might end up being just as valuable or more valuable than what you're trying to create. It's not unusual for a startup to go out of business, but at the end they have a valuable patent, or they can have a valuable trademark. Nowadays with the internet, you understand the power of a catchy name, a name like Uber. That name by itself is now worth billions, even though the idea can be copied pretty easily, and there are other companies out there who are trying to do Uber-like services. But clearly the person who had the foresight to trademark Uber understand that name itself is valuable. So again, that's a strategy where you're not only trying to create value through products and services, but you can also create value by capturing the intellectual property rights of what you're trying to do. It gives you an exit opportunity, and again, we'll talk about this later on. With intellectual property, you do need to be proactive, because intellectual property rights can go away. If you don't protect something, you'll lose it. It's not always there. So it's something that you need to focus on pretty early in your development. And of course, it makes sense to try to always improve your intellectual property position, because again, you're creating value for your company. Well, so what are the rights? We can say, okay, so what are these valuable intellectual property rights? 4 categories: trademarks, copyrights, trade secrets, and most importantly, patents. Getting a patent is extremely valuable. Trademarking your brand is valuable. You certainly want to copyright things. Copyrights is a traditional way you would protect books, movies, music. If you're writing music, you would absolutely know about copyrights, but also software. The number one, the easiest, the fastest way to protect software is through copyright protection. Just do a little quick survey here. Anybody been involved with patents? So you have some patent experience here. You work on a patent, maybe you're a patent holder. Trademarks, anybody done trademarks? No trademarks. Copyright. I'll show you copywriting is extremely easy. You can do it today. Trade secrets, you all have trade secrets. You're here because you have ideas and concepts. All those things are trade secrets, as long as you keep them secret. Next. Trademarking, again, the example is Uber. Another example could be Nike. I mean, that's a famous trademark. The Swish trademark. I mean, that little symbol is worth billions. And the great thing about trademarks is that they don't expire. As long as you're using a trademark, it is your trademark forever. Whether that's Microsoft, whether it's Apple, whatever. If it's your trademark, using it actively, it stays your trademark. It's only if you stop using it, you lose your trademark. By the way, I teach at South Texas College of Law downtown, and I run their trademark clinic. So if you have a trademark, you're interested in trademarking, talk to me. We provide free service. You don't have to work with law students. That's the price you pay for free service, but we can help you with trademarks at no charge. Next page. Copyright. Again, that is the way you protect music, books, presentations. If I wanted to protect this presentation right here, all I have to do is just put down copyright 2015 Tim Shen, all rights reserved. Those are magic words. You do that whether it's on your web page or on any presentation you do, that means it's copyrighted material. But if you don't put it on there, it's not. So right now, if I don't have copyright legend down the bottom, it's not a copyrighted material. But if you're doing anything, any presentation, go ahead and just put down those magic words. Copyright, put the year next to it, your name or the name of your company, and all rights reserved. That's it. By doing that, you have copyrighted your material. If you want to go further with it, there is a federal registration process. It's a little more complicated, but it's not expensive to do. And you certainly want to do that if you're protecting valuable pictures, music. All music is federally registered. If you write a song, please do a federal registration. You definitely want to do that. All the movies are protected that way. So, in software, it's pretty common for software to be registered. Trade secrets, and that's just the traditional way you protect your secrets, your information, your knowledge. It's not as easy as it seems. It does require certain steps to be taken to protect it. You have to identify what is your trade secret. You have to talk to if you're employees, you have to tell them what are trade secrets, what are the steps you're taking to protect it. So it's not automatic just because you're keeping it a secret. You do have to consider doing NDA. NDA is an easy way to protect trade secrets. The whole trade secret area is a topic that can go on and on. It would take more than 30 minutes to discuss. But you do have to realize it can be considered valuable. When you're talking to an investor, you can talk about trade secrets that you own. If you were Coca-Cola, you know, the Coke formula is your most valuable trade secret. And I don't know, maybe Domino's, maybe the pizza place have some sort of trade secret on their sauce. But there are trade secrets, and trade secrets can be considered valuable. But there's a process you would have to go through to identify it and to show that you're protecting your trade secrets. Yes?
You don't patent then your trade secrets, or are those you're keeping them within the company, or is there a part that you?
Yeah, it's one or the other. If it's a trade secret, you don't patent it. When you patent it, you're making a public disclosure. You reveal everything in your patent application. A trade secret, you keep secret. But that's the exchange. If you get a patent, you have a monopoly on your idea for 20 years. But a trade secret, you can hold on forever. It's up to you to decide which way to go. Yes, sir.
So in the NDA, do you have to be specific about what is non-disclosable?
I think that's important. A lot of people overlook that. They will just look at an NDA and just say, hey, I signed an NDA. But they should be listing all the things, items that you consider to be your confidential information. So when you do an NDA, I think it's good to have a little addendum saying, by the way, here's a list of the items I'm disclosing to you that I consider to be confidential. If you don't do that, they can say, hey, I didn't know it was confidential. At least you should be marking your material confidential. Put the copyright on there too. There's no downside. But you mark it confidential. If you don't say it's confidential, their response will be, I didn't know it was confidential. I've seen it before. What's the big deal? So mark it confidential. If you can, create a list of the information you're sharing with somebody and get them to sign off on it. That's the best way to protect your confidential information. Patents. And that's really the most important intellectual property right that you can accrue, is getting a patent. A patent can be worked as an offense. You can use a patent to attack the competitor. And a patent is also a defense. You can defend your property. Also, with a patent, it gives you the ability to fully disclose your invention without losing control of it. Because in a patent application, in a patent, you are disclosing your information. That is the exchange. The government is giving you a monopoly on an idea in exchange for you sharing this idea with the public for 20 years. That's the exchange. So by definition, if you're patenting something, you're telling everybody how to do something. But in exchange, you're getting a monopoly for 20 years. Clearly, it is valuable if you're a startup and have a patent. The red is all the startups out there, and as far as getting funding, venture capital back, you can see the blue line going much higher. If you have a patent, they're more likely to fund you, because a patent means you have some exclusivity on your idea, on your invention. It's an absolute selling point. If you have an idea, you need to think about how to patent it. If it's patentable, not everything's going to be patentable, but if it is, you need to think about that.
Clarification?
Yes.
So are you saying here that 97% of biotech startups with patents are venture capital backed? What specifically are you saying here?
Well, the chart, Sarah, when you pull the chart.
97% of venture capital backed startups have a patent.
Okay.
Another way of saying it is that they're backing you, they expect to see a patent.
Right.
If you don't have a patent, you're less likely to get backing. What can be patented? It's actually a very simple test. It sounds simple, but lawyers will make it very complicated. And the process is complicated, but basically it has to meet 3 tests. It has to be new. It has to be something brand new. But the brand new has to be non-obvious, which means you could take something that's new and make a small tweak to it. And that wouldn't be considered patentable if it's just a slight improvement. So it has to be what is considered non-obvious. And that's kind of like a legal standard. It's a legal standard like the word negligence. And if you're not in personal injury, but if I'm talking to a bunch of personal injury lawyers, they would understand negligence is a standard. So non-obviousness, the way to think about it is that it has to be more than just a trivial improvement over something. It has to be patentable. It has to be valuable. It has to be something that's different enough. And I'll talk about that a little bit more when we talk about prior art. Useful is a pretty easy standard to meet. Whatever you're doing here likely is useful. You're not going to be pursuing something that's absolutely have no use to anybody. So usefulness is a pretty easy standard to overcome. prior art search, something that you've got to do in order to validate your patent. Before you go file a patent application, you have to understand what's prior art. Prior art just means what's out there already. Your invention will always be judged against what is already in the marketplace. You think about, this looks like a patent drawing up here. Basically, whatever is going to be your invention, you will go out there and collect similar technology, what's called prior art. It could be patents, it could be articles, it could be whatever you find on Google. You put it on the wall, and then you look at your invention, and you compare your invention to the prior art. And you say, first of all, is it new? Is it something that has never been done before? Okay. Once you determine that it is new, you have to ask, is it non-obvious? So looking at the existing prior art with somebody who is skilled in the art, someone, a colleague, could look at the prior art, look at your invention, and just say, you know what, that is non-obvious. What you have discovered is really something different. It's unique. It's not trivial. It's not just like, oh, it's a little bit. So you change the color of your box to blue. Everybody's using green, you're blue. That is new, but it's not considered a significant improvement over whatever you're doing, okay? That's a very subjective test. It's done by experts. It only comes up during litigation. They will argue. Whatever you come up with, wherever you patent it, if it's in litigation, chances are the question is always going to be whether it was obvious or non-obvious at the time you invented it. Do your prior art search, and the best place to do it is on the USPTO, Patent and Trademark Office. You can, I think there's Google patents out there, there are free patent searches online, but ultimately you want to do the searching because you are actually the best person. You are the expert in your area. At some point in the patent process, you probably will have to engage a patent attorney. They are expensive, but the one thing you can save money on is a prior art search because you are truly the expert in your field. And if you can do the prior art search for the attorney, you will save a lot of money. If you can demonstrate to your attorney that what you're doing is new, non-obvious, then that's a very helpful process. Because your attorney will not know more about your technology than you. You are the expert with your invention. Next. So what will a patent give you? Let me see. These are legal words, right to exclude versus freedom to operate. The way to look at it is, if you have a patent, it gives you a way to go after somebody, to attack somebody. But it does not necessarily give you the ability to defend against legal attack. So if you have a patent, you can just tell someone else, hey, you're infringing my patent. That's kind of offense. But someone can still sue you, and you say, wait a minute, I have a patent. Just because you're a patent holder doesn't mean someone else cannot sue you, because it's possible that whatever you're doing is not only covered by your own patent, but it may be infringing on someone else's patent. So it's not an automatic defense. You don't get to say, wait a minute, I have a patent, so you can't sue them. They can still sue you. But you do have the ability to go out there and stop other people from doing whatever's in your patent. Yes?
So how soon should you actually file a patent? Like what tells you that, okay, now is the right time to do it?
I'll get to that right away.
Okay.
It'll come up very soon. Right here. Provisional and utilities. What has changed since 2003 is the timing of it. It's gotten to be much more critical when you file earlier. In the old days, I started in the old days. It used to be, the standard was first to invent. If you're the first to invent something, then you have time to patent it, and you don't have to rush to the patent office to file something. But in 2013, that was changed to first to file. So now when you have an invention, not only do you have to invent it, but you have to rush to the patent office to file it, because the race now is about who was the first to file versus the first to invent. So the answer is, you have to file your patent pretty quickly nowadays because of the change since 2013. If you can back up to the provisional, and that's what I'm going to talk about provisional. Back to the provisional. So filing a patent is expensive. Like, it'll probably cost you about $20,000 from start to end to get a patent, prepare, file, prosecute it, and get it issued. And it takes about 3 or 4 years. It's a long process. It's a very expensive investment, and you may or may not want to make that investment. Chances are you don't want to make that investment because it's expensive. The best alternative is a provisional, and you can Google this too. If you have any questions about a provisional, Google the word provisional patent. But It is one of the easiest ways to start protecting your invention. By filing a provisional on your invention, it is like putting a stake in the ground. You're saying, it's more like a layaway plan, if you're familiar with that. You want to buy something, you can't quite afford it yet, but you say, I want that, I'm going to put down a down payment, that is mine. As long as I make all my down payments, I will eventually own it. So a provisional is almost like a layaway plan from that standpoint, where you have an invention, a fully functional invention. It's not just an idea anymore. It's working, you're productizing it, but you want to protect it because now the standard is first to file. So you're thinking, okay, someone else is developing this, the people next door to me is working on something similar to mine. I need to file it right away, but I am not going to spend $20,000. It's way too much money. So you think about doing a provisional. A provisional is a way for you to start the process. It's only good for 12 months. So it's not forever, but you can start the process. The filing fee is only $100. You can actually do it yourself. Now, if you want to do it right, you probably should get a patent attorney involved, but they shouldn't be charging you more than a couple $100 to help you file a provisional, because a provisional is really like writing a research paper. You want to fully describe your invention, and then you file that with the trademark or with the patent office, and that is the start of your process. And we'll talk about that a little bit more down. Versus a utility. A utility patent is a true patent. That is a patent that's good for 20 years, and that's what, when people say, I have a patent, they're talking about having a utility patent. That'll last 20 years. It gives you this ability to exclude others, and it's more expensive, more complicated. You can't do it yourself. But a provisional is something that you can file yourself. Provisional. There's not any particular format. It can be anything. The only requirement with provisional is that you fully disclose your invention. So it can't be just a one-page, it cannot just be an elevator pitch. It has to be a detailed document that talks about your invention, the entire process. Think of it as like a research paper. It's detailed. It talks about your device, your technology, whatever you're doing, and it talks about how to make it. But it doesn't have to be in any particular format. Though it is helpful for a provisional to state the problem, what you're trying to solve, talk about the shortcomings of whatever solutions are out there already, and then talk about why you're doing your invention and how your invention is better. And then you got to talk about how you actually make this invention. It's not good enough to say, I think it would be great to have this new device, but I'm not quite sure how to make it. Well, that wouldn't be sufficient, because that's not what's called enabling. A patent has to teach people how to make something. Otherwise, it's not a patent. When to file it? As soon as possible. If you're publishing a detailed paper, if you can't file provisional, I know a lot of universities will automatically file a provisional every time a professor is giving a talk, a presentation, or something new, because it's inexpensive. The filing fee is on $100. And they have a mechanism, they have forms in place where you can just do it automatically, so there's no downside. So they're thinking, let's go ahead and take out $100 insurance on this idea, because if it doesn't go anywhere, you're out $100, which is really nothing when you talk about presenting ideas. So before you do a presentation, file your provisional if you can. Now, of course, the second bullet point is really more about the way it used to be when you're an inventor and the standard was first to invent. You could just keep on working on your invention. You don't have to disclose it, and whenever you're good and ready, you go file a patent application. Because as long as you can show you were the first to invent, you would win. But now, that's not the case anymore. Now it's the first to file. Remember, back to trade secrets, whatever, when you're talking about disclosures, having casual conversations with people could be a form of disclosure which can affect your patent. I know I'm going really fast on provisional, but I'm trying to cover a lot of different topics with you. And if you want to, I'll stay behind afterward. I'll be happy to do that. But provisional patent is actually something that's on, you can Google it and get a lot of answers. Yes, sir.
While we're waiting for this to change, since you brought up the idea that universities will sort of rubber stamp this kind of thing, can you speak to the value? So, since a lot of people in this room probably work at universities, we don't own our IP, the university does. So, what's the value then to the company of, is it still valuable to have a patent if we can just license it? Because again, the licensing patent technology can be that technology.
Yeah, and I'm not sure, I know different institutions are different. I don't know what your arrangement is, but typically in companies I work with, the employees have to sign all the IP rights to the company. You don't own any of it. You're working for the company. They own
It's true
everything.
at universities.
Okay, so if you don't own any of it, then other than being named as the inventor, getting the recognition, unless there's some sort of revenue licensing, revenue sharing plan, it's not yours. That's part of the contract you have with the university.
But a lot of universities have like things set up where like a 35% or 50% and goes back to the inventors. So I think that's more a common thing to have, to have a kickback to the inventors, because otherwise there's no point for
you
the
to
professors and students
Exactly.
to just go ahead with
that would be an incentive to you. If you know that your patent could, if it can generate revenue, you would get some money, then you have an incentive to get involved in the patenting process, because you can make some money. Absolutely, yes. Yes, sir.
Maybe it's already into, but once you file for the provisional patent, that means that you had some form of public disclosure?
Not yet. That's a good thing about provisional. You file your provisional. If you don't exercise it, you have 12 months to take it further. But if you choose to do nothing with it, it will just evaporate in thin air. Whatever you file with the patent office will just disappear. They will not release it. So there's not a downside to it other than being out $100.
Provisional searchable? Can other people?
No, they cannot. It's a secret. So it's a secret way for you to say, I want to protect something I have. I'm not going to share with anybody. I'm not sure I'm going to go to the next step with it, but I want to protect it. In the old days, people had this notion that, well, if I write my invention and put it in an envelope and seal it and mail it to somebody and it's not open, that doesn't really work. But the provisional does work. You file it with the Trademark Patent Office. It is in secret. You have 12 months to take advantage of that filing date. If you do nothing with it, it disappears.
So say that say the provisional patent expires and you file another one. I mean, are you allowed to just keep filing? Is that something that...
Absolutely. And I'll talk about that when we get to it. Let me see. Utility. It's not a patent workshop. Just to recognize when you are working on a patent, it's a much more complicated process. You have to make a full disclosure of your invention. Enabling is a legal term. You have to tell people how to practice your invention. Best mode means that you have to describe it as you see it right now, your best version. You cannot hold back on the patent process. You have on the disclosure process. You do have to disclose your latest and your best. You have to provide drawings, claims, that's legal language for describing your invention. You gotta have that. That's where patent lawyers get paid the big bucks to draft these complicated claims. Next page. We saw this timeline. If you file provisional, within 12 months you gotta file a utility patent, which is the follow-up patent. And you only get 12 months, there are no extensions. When it's over, it's over. And then once you file your application, at some point your application will get published. And that means everybody can see your invention. So once you actually file a formal patent application, you are saying, I'm going to throw it out there. And if the patent doesn't issue, it's out there. It's gone. It becomes what's called prior art. It becomes public knowledge. So you're gambling a little bit. You're saying, I'm going to make a full disclosure. If I'm wrong, everybody will know about it. So it's a little bit of a gamble there. Down there on the provisional, this is like voting, vote early, vote often in Louisiana. But here, with a provisional, you can actually file multiple provisionals because there are no limits. First of all, every time you have a new iteration of the invention, you could file another provisional. But remember, every filing is only good for 12 months. So what you can do with a provisional is this. And I've worked with inventors who will ask me to file provisional. I'll file one provisional. A couple months later, they'll say, hey, I improved on my idea. Great, I'll file a second provisional. We'll keep doing that, but we're always mindful of the very first one we file. That 12-month clock is ticking. As we get close to the 12-month, I would say, let's go ahead and file something. And the great thing is, in filing the formal application, I can group up all the additional provisions. There's no requirement it be one provisional, one formal application. A formal application can have lots of provisionals associated with it. The only thing you have to be aware of is just time. You cannot grab a provisional that you filed 24 months ago and try to bring it into your patent. As long as if you file 6 provisionals in the span of 8 months, you can put all 6 into one patent application. So, therefore, file it early, but keep filing it. If you think, hey, I have made a really major breakthrough, I want to go and file again, keep going.
When,
Yes.
when you keep refiling, because you get, I have a patent, a provisional patent, but it has a number.
Yes.
Like when you refile it again, or like a certain increase, you file with the same number, so you get a new number?
No,
How does
every
it-
time you file it with a new number,
Uh-huh.
the old number will go in. Remember, a provisional is a secret process. No one knows about it except you in the patent office. So when you file something, you're keeping track of the numbers in your filings. And the other thing is, if you don't want an old provisional, just let go of it. Pretend it was never filed. You're not penalized by it. They will keep your $100. That's it. There's no penalty. They don't remind you. They don't say, hey, wait a minute, didn't you file a provisional a couple months ago? What's happened to that provisional? It just goes away. But at some point, when you're ready to go forward, you group together all the provisions that you do like. If they're within the 12-month period, you can pull them all in and file an application based on all those disclosures. It's like taking the SAT, taking it multiple times. Forget the first score. Then they ask for all the SAT scores nowadays. But in the old days, just give them the best score. Same thing. Yes?
Let's say that prior to filing a provisional, you do your research and you look and you say, okay, I don't see any of this invention, so I'm going to go ahead and file a provisional.
Right.
However, at the same time, company A and company B have the same general idea. Do you get a status back saying, hey, you have, someone else has the same idea or
No.
anything like that? So you could be filing it and not knowing if someone has the exact same idea.
Absolutely. There's no checking the patent office. That's not. It's all in secret. Exactly. And that really only comes up if there's litigation or during the actual patent filing. If someone else files something, then they all get examined. This wall of prior art comparison. But with a provisional, it's just you're just putting things almost like a little cubby hole. No one knows about it. And if you want to go forward with it, you pull it down and you file it. Yes.
Yes, with the 2013 is the publication, the 12 months after publication still a thing, or in the US? Or it's still
It is. For a regular patent filing. Yes. Yes. Now there's publication requirement. And that's just to conform with what's happening worldwide, because elsewhere it's first to file and they have a publication requirement. So in 2013, we changed our system to conform with all the other popular patent systems out there. And that's the reason why now we are first to file, and there's also a publication requirement. But not for your provisional. Your provisional is never published. It's your secret.
But the other way around, like let's say because coming from academic institutions, it's like it happens that you present something at a meeting that no one really thinks that it's patentable, but then, oh, maybe it's patentable after all. And then you talked about it with a disclosure date. Do you still have 12 months from that disclosure date to file your patent?
Yes.
Is it still, because I know that was a thing.
Okay, I understand your question now. Another timeline you have to be aware of is the idea about public disclosure. Once you disclose your idea, after 12 months, if you have a public disclosure, you cannot patent something that's been in the public domain for more than 12 months. Is that what you're talking about? So once you present something, you have an additional jeopardy there, is that not only do you have to worry about the first to file, but also there's clock ticking on what's called the public disclosure requirement, which is, the idea is really simple. Once you share your invention with the public, you have a certain amount of time to try to claim it, because it wouldn't be fair. For example, you invented something and you go, oh, it's been out there for 20 years. Now it's really popular. Now I'm going to patent it and then start charging people more money for it. That wouldn't be fair. So under the US system, they allow you a 12-month window to kind of basically test out your invention. But within 12 months, you have to file for patent protection, either a provisional or a normal patent. Yes. And that's one of the reasons why you're giving a major presentation at a forum and you put it out there. You worry about someone copying it, and you worry about a 12-month time window. That if you don't file a patent application within 12 months, you can lose the right to ever patent invention, which is separate from someone copying the idea and running for the patent office and filing something. Yes, sir.
So you just said a provisional will extend your term past the 12 months?
Yeah, I know it's kind of confusing, isn't it?
Yeah.
It will extend the deadline to file something. there's a requirement that once you disclose it, now this has to do with disclosure, once you have made a public disclosure of your invention, then you have 12 months. And in that 12-month period, you can either file a provisional or a standard patent application, either one. So if you file a provisional, you get an additional 12 months beyond that. See, it's complicated, so patent attorneys like me can charge more. But if it was easy, you can all do it, right?
But if you disclose it in public and if someone just decides to go and file a patent, some similar idea, then probably they'll just be the first in line.
Exactly. So that's the problem nowadays. Now the standard is first to file. Yes, you disclose it, they can copy it and go and file it before you get a chance to file it, and they will say, well, I was the first to file. In the old system, you say, I'm the first inventor, but the first inventor doesn't work anymore. So that's why it's a race. You see that little man running? Now it's a race to file something, either because you made a public disclosure, or someone's going to copy the idea. Either way, it's got to be much more competitive. And patent is country specific. You get a U.S. patent, it's only good from the U.S. Every country has a patent system. It's very expensive when you think about worldwide protection, but there are places, the EU has a system to cover quite a few different European countries in one filing, but generally speaking, you gotta remember a US patent is only good in the US. So what does it cost? A provisional, the filing fee is only $100, really low. You can probably do it yourself if you want to give that a try. A standard utility patent, about $20,000. Legal fees, everything included. Going international, it just goes way high because, well, who knows? It's just extremely expensive. I certainly wouldn't recommend that to you unless you have the investors who want to make that kind of investing. Okay, so we have 2 case studies that we thought might be interesting for you to take a look at so we can discuss intellectual property. What I'm trying to do is, the focus of my presentation is this, to tell you that you have intellectual property. Whatever you're doing, you wouldn't be here if you don't have some sort of intellectual property. So the key is to help you identify your intellectual property and to talk about ways to convert the ideas, the methods, into tangible legal rights, which are patents, trademarks, copyright, trade secrets, because that creates value for you. So our little exercise, we have one dealing with someone who has developed an app, a software app. So take a look at the little fact pattern, and we can talk about what are the different IP rights they can get. And the second example is a medical device. So one medical device, one software, and take a look at it so that you can get a feel for what are the things that you can do as far as creating intellectual property rights.
So I think what we'll do is we'll just go ahead and group you guys by rows. And you guys can all get together and discuss. I'm going to give you either or of these companies to talk about. Get together, discuss where you think there might be some sort of IP, and then we'll discuss it together in about 10 minutes. Okay?
So we were given the health IT case study. So we had discussions about, okay, what about it is novel or useful? And I think, we can all go online and find doctors and, at a fixed price according to what's in our healthcare plans. But I think what makes this useful is just the ease at which that information is delivered via an app. So I think that's what's novel about it. We talked about copyrighting the software code. We talked about trademarking the user interface, the website, the logos, the catchphrases, anything on the website that can be trademarked, we would trademark. And then we also suggested to file a provisional patent, to grant us that protection as well.
Anybody else want to
So we
jump in?
have, you guys have anything to add? You guys are IT, right?
Yes. So just talking about the name, UberDoc, we thought maybe Uber would be already trademarked, and so you'd have to really do your prior art search before it. So I think that's the only thing that we had. We also had non-disclosure agreements with the Rice Engineering students, and to make sure that we list out what is the trade secret for this app.
We had similar things to other people, but we maybe had a question for the lawyer. So we had a debate as to whether the business idea itself, because I think that's what the question's actually asking, or that's what these people want to know, is the concept patentable? And I said it's not, because you can't patent business ideas. So anyone else could go do new code and do the same idea, and therefore the entire business itself is not patentable.
Right, and you're right about that. It is hard to just patent a broad concept, a broad method. But if you can put in wrap some technology around it and make it more specific, then the implementation of the idea might be patentable. Okay? And I use the example about Uber Dog to demonstrate some of these ideas that are, they seem pretty simple once you hear about them, but they were incredibly novel when they first, or no one was doing that before. You think about the fact that Uber can almost displace the entire taxi industry now with their concept, even though, when I first heard about it, I thought, oh, calling for a taxi on a phone, I mean, isn't that what a phone's for? Just pick up the phone and dial the number. But it does a lot more than that. Uber does the feedback. It has various mechanisms built in there. So if you were trying to patent it, you wouldn't just simply say, oh, I have an idea about how to call taxi faster. You would detail the actual implementation of this method, the mechanism, the process, all that, and hopefully it is patentable. But that's an example where you do want to be pretty aggressive about following the provisional, because the idea, once they hear about it, it's really easy to copy, because there are competitors out there now. Same with Groupon. I'm sure you've all used Groupon at some point, but this idea about coupons. Groupon did a great implementation, and they were successful for a while, but now, of course, it's easy to copy that method. If they could have gotten a patent on it, maybe there's a patent pending, I don't know what the process is right of Groupon, but when you have an idea like that, you do want to think aggressively about how would I be able to patent it, if possible.
I have a question about that. Like, if you're trying to sell something and you sell it, and to my knowledge, that's a huge disclosure that you have this property or this object or something that you're trying to sell. Do you have 12 months
Yes.
to give a patent? If not, then can you just modify it, tweak it to then?
Well, actually, I should have mentioned that when it comes to public disclosure, the number one thing is sale. A sale is the best example of public disclosure. So once you start selling something, you have 12 months.
But if you tweak it though, then you can modify it?
Sure. So if you tweak it, the question becomes, is it obvious from your own invention becomes your biggest enemy, because your invention is now the prior art. If you don't protect your invention, eventually it becomes the public domain. Then that becomes your most difficult prior art, because if all you're trying to do is just slightly tweak an earlier invention, then the best defense, the best way to attack your invention is your earlier one. That becomes your prior art.
Real quick, let's go ahead and finish up the health ID.
Okay, let's talk about it.
My idea was that we would just hire a large legal team that could come up with all kinds of creative ideas to defend it. And even if, health IT software, this kind of stuff is not usually defendable, and any technology that you even wrap around it, other engineers will just come up with a different way to do it with a different technology.
But the focus of my presentation is about creating value. So it's an alternative way, it's another way to create value. You're there trying to productize it, developing applications. At the same time, think about the legal part of it. To the extent if you can get patent protection, that's creating value for your company. If you really have a great name, trademark, Snapchat, great names out there, if you can get a good trademark, that could be valuable in itself. You certainly want to copyright wherever you can, from your software to your web interfaces, all that. But again, the focus is about, can I create some additional value that's different from the product or service itself? Yes, ma'am.
Right. And one thing that we forgot to add, but it's also a question. So, okay, great, we're using Rice engineering students, but would we need to instruct them not to do the coding using Rice computers and resources?
Yes,
Right,
absolutely.
okay.
There are two problems there. If you're using Rice students, smart bunch of guys, but that's one issue, is that they may have a contract with their university about using the equipment. But the bigger problem is what you might have seen in the movie The Social Network, which is that if you have an idea, like the Winklevoss twins, about the Facebook,
Right.
and you ask a programmer to do some coding for you, and the programmer, Mark Zuckerberg, is doing it without a contract in place, then by legal definition, he owns the code. The only way, the proper way of doing it, whenever you use a program for anything, you've got to put together a basic contract and, again, magic words. In there somewhere, you've got to say, this is work made for hire. If you don't use those magic words, the programmer can later on come back and say, wait a minute, it's my code. So, work made for hire. If those are the magic words. You can also say, look, you don't own this. If you want to use plain English, you don't own any of this. You're doing this work for me. I own everything. You can do that too. But you don't you say, by the way, you are a contract programmer and you're performing work made for hire. And if you don't do that, which didn't happen with Mark Zuckerberg, you can just say, wait a minute, the Winkle vase, that was their idea, but I'm the one, I wrote the code, I'm the inventor, I'm the original inventor of this code, it's mine. Because the Winkle vase never paid him any money for it. He just went off and wrote it. There was no contract in place. He went, wrote it, and look how it's turned out. That's the thing to remember when you're hiring a couple guys to do programming for you. Got to put at least a basic contract. And listen, you can always Google that. Google basic, programming contract. Put a one-page contract together, but at least put the words "work made for hire" in there somewhere in your contract. Yes,
But, so, I do my own programming, but so there are certain things like it's defined by math, and that you just kind of bring your way to program that specific math to do a little piece of your product. So, so that piece of how that, single value composition, like SVD is done, is not my creation.
Right.
So, but I still program it my own way, or maybe I'm using some function that might not pass. So, how can I still claim property over the code, or how does that work?
Well, you're really only claiming the work product, your computer programming. You're not claiming ownership of the actual math. It's like writing a book. You're using all the existing words. You're not creating any new words, but you're going to arrange these words in a new and interesting way and put it in a book, right? Every word is known as the world, nothing new, right? You don't own any of the words, but you own that combination, the way you have string together all those words. That's your invention, and that's your copyright.
For software, isn't the algorithm the one and only thing that's really patentable? That was my feeling before tonight, that whatever for that health IP, let's say that they came up with a sweet algorithm that made that linking to docs and everything, that this is the part that's patentable, not just the concept of Uber duck in itself.
It is the algorithm, it's the actual implementation. So as I mentioned earlier about patent, about have to be enabling best mode, a patent application is never one page. It's always multiple pages. So you're starting with the idea. For example, I studied the Amazon one-click method. When they got a patent on that, you might have been too young to remember it was a patented method. But one-click seems so, you know how that works. You click on once, right? But when I first came out with it, it was considered a new way of ordering products online. You can just point to your product and click it once, and it gets shipped to you. So Amazon developed an entire algorithm, entire method around it. It wasn't just my patent is click once on the product icon and it will happen tomorrow. That wasn't it. They talk about how it is cataloged in the database system, and from the database system it's retrieved. So it has to go through an entire algorithm, entire implementation of it. And that's why they patented it. But people derisively talk about, oh, how can you patent one click? How big? What's the big deal? What's the implementation of it that are patented? Algorithms, everything along with it.
And what makes them strong is that they are able to pursue their patent, because there's a lot of loopholes, right?
Absolutely, and the way that played out was Amazon got a patent for the one-click method, and this was about 1999, 98 timeframe. And about the same time, Barnes & Noble was trying to get onto the internet, trying to also be competitive in the online space. And Amazon was able to use the patent as a sword, offensively, to attack Barnes & Noble. And for a duration, they were able to shut down. So during a very critical Christmas season, maybe it was 1999, while Barnes & Noble was trying to go online, also with their one-click, Amazon filed a lawsuit and shut down Barnes & Noble. So they missed out on a critical Christmas season, which, of course, we now know Amazon owns the world. But that was one way they were able to use a legal sword to go after and beat Barnes & Noble with it. Ultimately, I think the lawsuit was dismissed or settled. It didn't matter. The important thing is that during that initial time frame when Amazon was still kind of a startup and trying to get traction, they were able to shut down. Believe it or not, Barnes & Noble used to be bigger than Amazon. They were able to shut down Barnes & Noble by serving a patent. So that patent was incredibly valuable to Amazon in much respect.
Let's go ahead and do the second case study. So I think we're starting with this group.
So we have a couple of questions about this. The first thing was, because it's an integrated cardiac assist pump, the question is, are we developing this inside a university or hospital, or just as individuals? If it's a university or hospital, then I think things are a little bit more straightforward, because the university or hospital would file the patents for us. If we are an individual or a team doing this by ourselves, then the first thing we stumble upon is the extensive market research, which we couldn't disclose anything during this time. Now, if we are far enough that we are doing large animal preclinical trials, we have two options. One would be to file a provisional patent, or the other would be to go with a utility patent. I think if we're trying to get money from venture capital, we'd probably go with a utility patent, because it's going to be, for a large animal preclinical trial, would probably need a lot of money.
I guess, I mean, the way that we were seeing it is that there's nowhere in there anything said about IP protected at all. So what we will basically say, the investors actually would just not be interested. As much compelling our story can be and how much we want to go into animal studies, if we don't have patents, and we're actually discussing whether you need to have granted patents or if applications are good enough to get investors, but basically we will just tell them that we screwed up.
So we agree with the first group that mentioned the utility patent, because we're trying to get the investor to invest to us. And because also we are trying to initiate the preclinical trials in large animals, we will probably have some sort of FDA clearance or some kind of green light from FDA in order to move forward, and I believe that is a valuable thing for investors to hear. And the other thing is that apparently we have talked to people to be potential employees. We would have non-use, non-disclosure form in place, and also contracts before we actually hire them. And with the product or the device itself, if the team was smart, they would probably have a trademark to go with it on top of the patent.
So clearly, for this example, medical devices, they are very patentable. If it's new, non-obvious, if you develop something new, obviously, you definitely want to get a patent. And I think your investors absolutely will start off by asking you about IP rights, whether you have patents or not. So,
would they accept a provisional, or would you
yes.
be already?
Well, okay, so
Yeah.
it's critical to be able to talk to your investors about patent protection if you're doing medical devices. Provisional, there is no downside in filing a provisional. If you file a provisional, think of it almost like a first draft. If you have a first draft, file a provisional. Provisional is like a first draft. Let me stress, there's no downside. The only downside is that you could be out $100. Okay, you say, well, I want to save my $100, so I want to go and just work on this full application. But by doing that, you run the risk that someone else may file before you. You run the risk that some disclosure has been made out there. So it is the cheapest insurance in the world. You put together a provisional, you talk to a patent attorney, or you get on Google, you figure out how to submit the form, you put $100 into it, because even if you're completely wrong, No one would know about it. It goes away. It's in a cup you hold somewhere. It doesn't. But if you were right, you can say, "Wait a minute, I have a provisional. It's sitting out there. You can go out there and bring it back in. It's like a time capsule. You get to do a redo." So there's just, I cannot stress this more. Just saying, there's no downside other than losing $100. That's the only downside of filing a provisional, because your regular patent application, you could be working on, I have done this before, I'm working on a provisional and a regular at the same time because I'm in a rush. So the inventor is slow to get drawings back to me. I just go ahead and file the provisional. I don't care. I'm waiting. He's on a vacation. He's somewhere. I can't reach him. So just be safe. I just go ahead and file the provisional. If he's mad about $100, I'll just go ahead and eat it. Okay? But it's not. There's no risk. No, you're not penalized. Oh, wait a minute. You filed a provisional. Why did you file a provisional? This doesn't come up. It's automatic. So you definitely want to think about patent, when you have a medical device, think about patent protection early, because your investors will ask about it. You can't get around that. About the employees, it does get complicated. You're running a small company, you got to make sure employees have signed their patent rights. So if you're just working with a bunch of friends, nothing in writing, then it could be a mess. So you got to figure out. Because if you have a company, then who owns the IP rights? It's just, if you're all co-inventors, you co-share this technology. So you got to have contracts, but especially if you're going to be hiring employees, not inventors, you're regular employees. They got to sign some sort of basic employment agreement, agreeing to assign all their rights to you, to the company. Otherwise, they could argue that they own it. And again, the last topic is the non-disclosures. You'll be asked to sign NDAs. Always be careful. An NDA, a non-disclosure agreement, shouldn't be more than 2 pages. If you're talking to IBM, they'll give you a 10-page document, which I think is just so obnoxious, because there's not that much to say in NDA. But if you are signing, if you are signing an NDA, make sure there's no language in there like they own everything that's disclosed to them. Very common. They may put in a non-compete. All these things you got to be very careful. So if you don't understand it, don't sign it. And if it's long, you're really suspicious, it really shouldn't be more than 2 pages. 1 page should be enough. But more than two or three pages, be suspicious. Yes, sir.
What does an NDA buy you? Like, say we have a non-disclosure agreement, and we talk, and then she goes out and does exactly that.
No offense. Technically, so a non-disclosure is a contract. It's an agreement that you make with another person. And if they were to breach it, so the non-disclosure is saying, I'm going to share my secret with you, and you agree to not use it except to evaluate our relationship or whatever you want to do with it. But you agree to not use it and go develop separate products. It depends on what is being agreed upon by the 2 parties. And if they go and take your idea and do something that they shouldn't be doing, they are in breach of a contract, and you sue them for contract breach.
You do have more information about some of the pitfalls and such.
Right.
So.
Okay. And the NDA and the other thing is assignments. You see assignments as, I guess, graduate students, you assign everything over to the university. You don't really own anything, so be aware of that, that's important. I guess some students may have assigned assignments, I mean, I don't know. Or maybe it's more related to how to use their equipment in school. They cannot use their computer equipment to do personal work, I guess, I don't know. Maybe there's restrictions about that. Yes, ma'am.
A question on the provisional.
Mm-hmm.
It seems like strategically you want to file something that's as general as possible, so later on then you can kind of claim aspects in your utility patent. Is that right?
Well, you want to be broad, but you cannot be so broad without specificity. You still have to, you cannot just patent a mere concept. You have to disclose how you're going to actually implement it and make it work. So it's not enough to say, oh, I have this Uber idea about taxis and whatever. You have to say exactly how you will implement Uber, how you will exactly implement one-click method. But with a provisional, you can start off broad and file additional provisionals. But if your disclosure is overly broad, then ultimately you cannot get a patent because it's considered too broad. Yes, sir.
For the medical device example, so if you're in that situation where you're ready to file a patent, but you're going to do some more research, so you're not like finalized yet, what would you go for a utility patent? Because like, what if the research improves your, your concept or your technology?
And that's the problem with filing a patent. When you file a formal patent, it is a snapshot of what you're doing at that moment in time. you cannot amend it. You're taking a picture of where you are at that particular moment. So yes, if you improve on it, you cannot go in there and change the text. So it's just it's a separate patent, separate issues. It gets complicated.
So you might want to go with provisional for the first 12 months.
Yes,
if you know
when you think about provisional, you keep taking multiple pictures, it's like showing a slideshow. I was on vacation, a bunch of pictures, but when you get to the actual application, you have to pick the picture you want, the one and only picture. But with the provisional, you can have a bunch of pictures of your invention, group them all together, and from there you come up with one composite picture. But the patent application, the disclosure of the patent application can never be changed. Once you file it, that's it. You cannot add to it, you cannot delete it, you can punctuate it. If there's a typo, you can correct it, but you cannot go in and say, oh wait, one more thing, it's too late.
You can, like, there's that continuation in part thing, what does that entail?
Yeah, but a continuation in part is you're disclosing new material. There's a way of filing another patent that relates to an earlier patent.
Without infringing?
Without,
Is that
yeah.
the idea?
You can have what's called a parent patent, a child patent, you can go on and on and on. Another way for patent attorneys to make a lot of money is, yes, there's a way to string it out, but your idea itself, whatever you capture in time, you can only protect that with respect to a certain time frame. You cannot extend the life of the patent. With pharmaceuticals, boy, you love to be able to extend the life of things. You cannot. Whatever you disclose with your formulation, that is it. I don't care. There's no way to actually make Prilosec longer than 20 years.
Yeah, but they do with Nexium because the RS, they play with RS and engineers and then they switch.
Different formulation, right?
Well, yeah, but it's the same drug, they just went to pure engineering.
Someone had to get up and say, Nexium, it's not only new, but it's not obvious.
It's not new. It's just not what was there before.
That's right.
Let's go ahead, do you want to just finish?
Yeah, we wrap it up.
We could probably go back and forth with questions, it's not that much longer.
We can save that till the end, maybe, if we can take.
Yeah.
Absolutely, I can stay. I haven't had a slice of pizza yet or
Yeah.
beer or something. I'll be happy to talk to you. So what do we have left?
We have just a few bits left, so let's go ahead and finish out. So, last section. It's coming to close.
All right. Oh, right here? Going different. I think I might have covered the non-disclosure. Again, be careful about signing non-disclosure agreement because if you're signing it, then you are on the receiving end of something, of obligations. So be careful about what obligations you're taking on as far as non-compete, as far as ownership. It's like these click wraps you do when you're getting software. Who knows what's in there, but you click on it and you move on. That's probably okay with consumer software. But if you're meeting with IBM and they give you a 10-page document, you got to read it carefully. You cannot just say, oh, is this okay? Can I sign it? Sure. It shouldn't be that long. No more than 2 pages. IP rights assignments, you know that as if you're working for somebody, they want you to sign all the rights to them. If you have employees, you want all their rights to come to you. Yeah, it's very important. If you don't have these assignments, there's going to be a dispute. Mark Zuckerberg, Winklevoss, as to who really owns what. Exactly. Contract programmers. Magic words. Work made for hire. For hire is good enough. It's work made for hire. To make sure that the programmer is working for you and you own their whatever intellectual property is developed by the programmer.
Yeah, we'll have a few more questions in just a minute. All right, so thanks for coming.